Well, I do not recommend allowing the distributor or licensee to register your trademark in China because you may put yourself at substantial risk, and you may even face the risk of being sued for trademark infringement in China. Instead, you should register your trademark by yourself, and it is even better for you to maintain the exclusive ownership of all your trademarks worldwide. One more thing, you should probably sign a distribution or license agreement with your distributor, and you have to make it clear that 1. You own all your trademarks, and 2. You're just licensing the distributors to use these marks. Yes, it is necessary for you to record the assignment in a timely manner if you get trademark right through assignment from others. For one thing, you cannot enjoy trademark right until the assignment was recorded with China Trademark Office. Before the assignment gets approved, you can only rely on the trademark agreement, but it is possible for the assigner to breach the agreement while maintaining the ownership of trademark. In that case, you may not be at advantageous position. For another, if you do not get the assignment recorded, but you intend to enforce trademark against a third party, you may have to bear a higher burden of proof, which means you have to prove that there's a license agreement authorizing you to take actions. Yes, it is necessary to conduct customer recordation in China because customer recordation is an effective way to ensure trademark protection in China. There are two types of customer protection. One is passive protection and the other is active protection. For the passive protection, the trademark owner first files an application and then the customer takes actions accordingly. For the active protection, it is the customer that takes the initiatives based on the trademark recordation. So the advantages of a customer recordation is that it can initiate customer active protection. If the customer discovers any imported or exported goods suspicious of infringing trademark right on record, they will send notice to the trademark owner. The owner may request the customer to detain the suspected infringing goods by depositing a sum equivalent to the value of the goods. Then the customer will make an investigation and dispose of the infringing good if trademark infringement is found. Chinese authorities will actively take legal actions against counterfeits in China. The Public Security Bureau, the PSB, will take legal actions against counterfeit in criminal cases. If the sales amount or illegal profits of counterfeit exceed a certain amount, meet certain threshold, the PSB will take cases transferred from the administrative authority, like the Administration of Industry and Commerce, AIC. And in another case, the trademark owner may also contact PSB directly to raise a case. The AICs are responsible for checking and investigating counterfeit during their regular and urgent inspections. They can also take actions against counterfeit based on the application of the trademark owner. And the AICs can handle administrative cases quickly, and the procedures are pretty straightforward. China Customs plays an important role in cracking down on counterfeit at borders. China Customs will take the initiatives based on trademark recordation, and they can also take actions per the application of the trademark owner. Yes, I would say the risk of trademark infringement is relatively high if you use a trademark that has registered by others. Although it is possible to claim prior use defense, the prerequisite is rather strict. You have to prove two things. One, you have used the trademark prior to the application date of others' registration, and your trademark had obtained certain reputation through your use in China. Even if such defense is established, you would still be required by the court to use your trademark within original scope and attach additional signs for distinction. Based on judicial practice, only in limited cases does the court find no infringement. In most cases, the court still ruled trademark infringement. However, precedent shows that if the registered trademark owner never used the trademark in commerce, the court generally would not award damages.